Good afternoon, Ms. Covington. I just have a few questions for you. No, Ms. Hyde, you worked as Bancroft's personal assistant, didn't you?
Yes, I did.
So you were at the Black Bear Casino quite often.
Yes.
So you were there enough time to see multiple people gambling.
Yes.
So you were there to see high rollers gamble.
Objection to relevance, Your Honor. May I be heard?
Yes.
Whether Ms. Hyde saw high rollers gambling in the casino does not make any fact in this case more or less probable.
Your Honor, if I may proffer.
Yep.
What this line of questioning is going to show is that my client, Chase Covington, gambled quite often, which completely goes to our case.
Can I respond?
Yep.
Whether Chase Covington gambled or not has nothing to do with the bribery that occurred between Chase Covington and Avery Bancroft.
Your Honor, this is laying proper foundation to show how my client, who was being accused of depositing $200,000, put that $200,000 into her bank account. This is imperative to our case at hand.
Overruled.
Yes, Your Honor.
Let me just ask that again. So you saw a lot of high rollers at the casino, correct?
I mean, I guess if you want to say so, I was his personal assistant. I really wasn't down there.
Okay, but you saw Chase Covington gamble.
Me personally see Chase
Yes.
Covington gamble? I guess so. I was in the casino.
Right, and you would say that Chase Covington is a streaky type of player, correct?
I guess he's a streaky. I don't really focus on him that much.
Right, but you would say that you even saw him win quite often.
When I was there in the casino, I mean,
Yes or no, Miss Covington, or Miss Hyde? Did you or did you not?
I seen him play before, but I don't know if he was streaky or not.
Just to clarify, is it your testimony today that he's not a streaky player?
No, I guess he's a streaky player.
So just to clarify for the jury and everyone present,
Objection asked and answered, Your Honor.
Your Honor, she has yet to answer my question clearly. I'm just for
Can I
clarification.
respond? She clearly said no the previous time he asked it.
I'm going to overrule, just finish this question, no more.
Just to clarify, you would say that Chase Covington is a streaky player, yes or no?
I don't really know Chase Covington's playing habits, but I guess yes.
Okay. And you saw her win?
No.
Objection asked and answered, Your Honor.
Your Honor, just clarifying, just to want to know if she saw her win.
Can I respond? She's clearly already answered this question multiple times, Your Honor.
Your Honor, the question I previously asked was streaky player. This is going to show that she won. In this witness's affidavit, there's even evidence to show that she saw her win.
Can I respond, Your Honor? He previously asked if Ms. Hyde had seen Ms. Covington win, meaning that this is asked and answered.
Sustained.
In fact, Ms. Hyde, you saw Ms. Covington walking out of the casino with multiple amounts of chips, stacks in fact.
No.
Is it your testimony today that you never saw Ms. Covington walk out with stacks of chips?
Yes.
You were aware that you had 24 hours to change any part of your affidavit, correct?
Yes.
Right. A permission to approach counsel and witness with what has been marked as Tracy, but what has been marked as Corey Hyde's affidavit.
Which lines?
62.
Go ahead. No objection, Your Honor.
Ms. Hyde, this is your signature on the last page, correct? If you could please flip to line 62.
Objection to line foundation, Your Honor. May I be heard?
Yes.
To impeach a witness, you need to first clarify whether they've had 24 hours to change it, whether their signature is at the back of the document, and whether that's their name at the top of the document, and whether it's a fair and accurate copy. He's only done 2 of these 4 things, meaning he cannot impeach the witness beforehand.
Sustained.
Your Honor, okay. Is that your name at the top of the document?
Corey Hyde, yes.
And is this a fair and accurate copy?
Yes.
All right. Could you flip to line 62, please? If you could read along with me as I read aloud. Covington would leave carrying a huge stack of chips worth more than I made in a year. Am I saying that correctly?
Yes, you are.
Thank you. Permission to approach and retrieve.
Go ahead.
Ms. Hyde, I want to talk to you about your experiences with Officer Keenan. The first time that you met with Officer Keenan was to discuss gambling licenses, correct?
Objection to relevance, Your Honor, may be heard.
Yep.
Whether Ms. Hyatt has talked to an officer about certain casino aspects is not relevant to whether Corey or Ms. Covington and Mr. Bancroft made an exchange of money in return for Ms. Covington's vote.
Your Honor, this testimony should go to show how Officer Keenan, a person that utilized this Ms. Hyde as an informant, if he properly trained her.
May I respond? Whether she was an informant or not is not relevant to the exchange happening. Mr. Keenan was not mentioned at all on direct examination, and it's not relevant to the exchange occurring.
Your Honor, may I be heard?
Sure.
Officer Keenan was mentioned multiple times during direct examination, and if not for Officer Keenan, Ms. Hyde would not be here today because she was his informant.
May I respond? Whether Ms. Hyde would or would not be here today is not a contention in today's case. What is in contention in today's case is whether an exchange was made between Ms. Covington and Mr. Bancroft.
As the bar for relevance means that there has to be like any probative value, I'm going to allow this line of questioning.
Yes, Your Honor.
Just to repeat my question, you met to discuss gambling licenses, correct?
With Mr. Keenan?
Yes, Officer Keenan.
Yes, we set up a meeting.
Right. And during this meeting, Officer Keenan blackmailed you into cooperating with this investigation.
Your Honor, once again, I'd like to object to relevance. May I be heard?
Overruled.
Yes, Your Honor.
To restate my question, during this meeting, Officer Keenan blackmailed you to cooperate with this investigation.
I don't know if I would call it blackmailing. He just told us that I had possible violent gambulations against me.
Right, but he brought these gambling violations to light in order for you to work with him, correct?
Yes.
Right. And he said that he would throw you in jail for these gambling violations, correct?
Yes.
Right. And you said that if you helped him, he said that if you helped him, all of your troubles would go away.
Objection to hearsay, Your Honor.
Your Honor, this isn't going for the truth of the matter asserted, rather for the effect on the listener.
May I respond?
Yep.
Your Honor, the truth of the matter asserted in this is whether his statements led Ms. Hyde to accepting his proposal, meaning that it does go for the truth of the matter asserted. And
Your
unless they
Honor,
can lay the foundation
I'm
as
just
to why it affected the listener, then it is not admissible.
going to show that these statements kept Corey Hyde into working with Officer Keenan. Nothing about the truth of this statement.
I'm going to allow this, but on the condition that the jury be informed that these statements are only to go towards the effect on the listener and not to be considered as to the truth of the matter asserted.
Yes, Your Honor.
Thank you, Your Honor. Ms. Hyde, you never committed any gambling violations, did you?
No.
But you were afraid that if you did not work with Officer Keenan, you would be thrown in jail?
I thought it was the right thing to do.
And there was a time during one of the meetings, or after one, that you tried to quit, correct?
I got cold feet.
Right. And Officer Keenan said to you, backing out now would be the worst mistake of your life.
Objection to hearsay, Your Honor.
Once again, as per your previous ruling, this is only going to the effect on the listener, not for the truth of the matter
Respond.
asserted.
As long as you once again put a limiting instruction on the jury, clarifying that it is in fact for the effect on the listener, then I am fine with allowing this statement in.
All right. Well, the limiting instruction will be put in place on this as well.
Yes, Your Honor.
And he reminded you of the charges that were brought against you?
Yes, he reminded me that I might have possible charges brought against me.
Right. And at that time, you decided to stay on board.
Yes, I stayed on board.
Okay, I'd like to talk specifically about Officer Keenan's actions, specifically on April 16th. Ms. Covington didn't show at that meeting, correct?
Yes, she didn't show.
Once Avery Bancroft left his suite, Keenan was absolutely outraged, wasn't he?
Yes.
He once again made sure that you would know that you went to jail if you didn't find Avery Bancroft, right?
Objection asked and answered, Your Honor.
Your Honor, I've never asked this question.
Respond. He previously did ask whether or not Ms. Hyde was threatened with jail if she didn't cooperate with Keenan's proposal.
May I be heard? This is a statement that Officer Keenan had said multiple times, and I'm specifically talking about April 16th.
May I respond? Just because he said it multiple times does not mean that it's not asked and answered if it's already been asked.
I'm going to overrule because this is a different statement this time.
Yes, Your Honor.
Just to repeat my question, on April 16th, Officer Keenan reminded you that you would go to jail if you didn't find Avery Bancroft.
Officer Keenan, on April the 16th?
Yes.
I'm sorry, can you repeat the question?
On April 16th, Officer Keenan reminded you that you would go to jail if you didn't find Avery Bancroft.
Yes,
But the fact that Avery Bancroft and Ms. Covington were at the meeting was not your fault, correct?
yes, Avery never showed up. I mean, Bancroft never showed up.
Thank you, Ms. Hyde. No further questions, Your Honor.
Thank you.